Land Reform and Rural Development. I'd also like to take the opportunity of welcoming the officials of the department, first led by the DG, Ubao Shabane. I think I've seen him. I'd also like to take the opportunity of welcoming the rest of the officials of the department, by the ministers, PLO, also our staff. Good morning. We had honorable members, wonderful engagement on our public hearings on the upgrading of the land tenure rights, where we had various stakeholders, NGOs, representatives of communities and interest groups that came to present to the portfolio committee. Also had an engagement from individuals that wanted to make oral submissions to the portfolio committee. Over 5 days, we were able to have these engagements with the South Africans across the landscape of our country. We will today be inviting the department to give us its own presentation in terms of the upgrading of the Land Tenure Rights Amendment Bill, whereas we are hopeful that having engaged with that, we will then be able to engage with our content advisors on the submissions they've received, also to receive a legal opinion, but I think that will be dealt with in the next week's program. Today, we have the department, which I would like to welcome the Department of Agriculture, Land Reform and Rural Development, and request Ubao Shabane to lead us in the presentation from the department. I thank you. Ubao Shabane.
Good morning, Honorable Chair. Morning, honorable members. Thank you for this opportunity. We have a presentation that will be led by Advocate Ramasala. We did circulate, albeit a little late, the inputs. Without much further ado, I'm going to invite Advocate Ramasala to lead the presentation. We've got a number of officials in the department that are part of the meeting, coming from the different branches of the department that are mostly going to be affected by the amendments insofar as the implementation of the bill once it becomes law. Honorable Chair, honorable members, can I please invite Advocate Ramasala to lead the presentation.
Thank you, DG, and good morning to the Honorable Chair, honorable members, the DG once more, and colleagues. My name is Ramasala. I am part of a team of officials in the department that is responsible for drafting legislation. We have submitted 2 documents. Firstly, the presentation in a slide form, which is fairly short presentation, and also a comprehensive document that seeks to provide feedback on the comments that we've received in detail. On the presentation itself, I've asked one of my colleagues to assist in projecting it, Mr. Sibifelo, if you can do that for us. I can't see it from my side. I hope that is being projected, Honorable Chair.
We are waiting for it to be put on the screen. It's still not visible.
With your permission, Chair, can I proceed while it's being put on the screen? I take it that honorable members have received copies. I'm not sure how, Chair, to proceed. Can I proceed, or do we wait for the projection of the submission?
Would like to get assistance for it to be projected so that the honorable members may be able to follow as you present. We also indeed receive the presentation, so we will also try and open it up on our gadgets. Can I therefore ask whomever is putting the presentation on the screen to do so? Manyamza, any assistance on your side or from IT?
I will get IT to assist us, Chair, but it's always difficult to share a presentation when we have already logged in. It's easy for me when we are not yet started.
Okay.
Chair, thank you.
Baushabane from the department, is there anyone that is loading the presentation?
I'm going to request Ralph, Chair, to load it, Ralph.
Okay.
Good morning, DG. The system doesn't allow me. I've asked Syspumla to assist.
Okay, let's just see as best how we can be able to upload the presentation. Then we can proceed.
Thank you, Chair.
Perfect. I think I spoke too earlier. The presentation was up. It's been taken down again.
The system doesn't allow me to upload. Yes, and I've requested Pumla to do so. She says they can also project if they have the host the rights. And now I see someone has uploaded to the science.
Can we proceed?
Honorable Chair, the document that is on the screen is not the presentation. It's not the one that that we're going to be presenting. It's a SAYAS report.
Okay, okay.
We will wait maybe for a few minutes to see
Fine.
if the correct one is being projected.
Can you see the document, Chair?
Not yet on my side. There is seemingly a black square in the center of my screen. Honorable members, are you able to see it on your side?
No, Chairperson, there's this funny striped block over the
Yeah.
word presentation on my side.
Yes, that's what I'm seeing as well.
It seems as if I was not granted the right to use the system. There's it. There's it. Oh, I see. I'm sure from the other side they're trying to do something out. Yeah.
Thank you, Chair. Can we make Mr. Ramasala a co-host so that he will be able to share the document? Because
All right. So, any luck? Are we winning?
Madam Nyamza, can we remove what is on the screen, and I will try and see whether I cannot upload it from my side. I'm going to try, Honorable Chair. Honorable Chair, can I just check whether I've been able to share the presentation with members? Can they see it?
Not yet. We're just seeing your email between yourself and Ralph. So if you can open the presentation. For now, it's just the email.
Because I have the presentation on my screen, it says that I'm screen sharing.
Honorable member, can you see it?
No, Chairperson, I see it looks like it's frozen on our side because I see there on the left-hand side, you can see the wheels turning.
Okay.
There's a little blue one, so I don't know, maybe if he just needs to stop and reshare it, because maybe I think his computer is a bit deurmekaar.
Okay. Let us close the presentation and open it again. And let's see if we can win in that regard.
Okay, I don't know if your mic is off or on.
Your mic is on.
Yes, it's Madam Tana. Why or what's my?
I tried again, which on my screen it shows the presentation.
Okay. We're not winning because on our side we don't see the presentation and nothing is opening. Manyamza, any suggestions?
Chair, while waiting for it to come back to me, let's continue. Members will have to use the presentations on their gadgets.
Okay. Let us proceed, and then we will try and get IT to rescue the situation while we are proceeding. So you may continue.
Thank you, Honorable Chair, and our apologies for the hiccup. The presentation itself, as I've indicated, is fairly short and straightforward. It starts with introductory remarks on the process up to this presentation. And then we highlight the comments from the public that are directly linked to the provisions of the bill. And then we indicate the comments on the bill that we support as the department. And then we also deal with comments that have been made in general on land tenure, and then concluding remarks. On the comments that relate directly to the bill, maybe starting with the introduction again, we have noted that the portfolio committee invited public comments and that it received written and oral submissions. As the department, we were finished with copies of the written comments. We were also following on the oral submissions that were made to the portfolio committee. And the comments that were received were, some were on the actual clauses of the bill, but the majority were on land tenure in general, not necessarily on the specific provisions of the bill. And then this is our response to the comments furnished to the committee. On the comments that directly relate to the clauses of the bill, under clause 1, paragraph B, there is a comment that was made that reference to the words Schedule 1 must be maintained. If members look at the bill, the manner in which it is drafted, it suggests that the words Schedule 1 must be deleted from the Principal Act. It is correct that reference to Schedule 1 must remain in that paragraph. That is the first comment made. And then under clause 1 again, paragraph C, where it deals with the notice that must be published after the ministers receive an application. We have received comments that in addition to the government gazette, there must be personal notices or letters served on family members and the persons who have an interest who may be known. And also there is a proposal that the notice may also be affixed at local municipal offices, notice board in local languages for any person who may have an interest in the application to respond to the application. Thirdly, under clause 1, paragraph C again, where it talks about the inquiry, where the minister issues an inquiry to determine the facts around the application. The way the bill reads currently, it suggests that an inquiry will follow with each and every application that is made to the minister. A comment has been made that an inquiry must only be instituted where there is an objection to the application the minister has received, and that where there are no objections, the process of conviction must proceed. Also, there was a comment made that in that part of the bill, reference must be made to the sections of the Principal Act that deals with the powers of the person who will be doing the inquiry to assist the minister in determining the facts around the application received by the minister. And then also there was a comment made, Honorable Chair, that the person who is appointed to conduct an inquiry on the application received must have the power to mediate between the parties when the person gathers facts, if there are disputes that could be dealt with at the level of the investigation, that person be able to mediate between the parties. The next clause, still under clause 1, paragraph C, the manner in which the clause is written on the powers of the minister after receiving the application suggests that in addition to determining the facts around the application, the minister makes a decision whether there must be a conversion or not. Basically, what must happen is that the role of the minister, it must be made clear that is basically to determine the facts around the application and to assist with the mediation where there is a dispute, and that the right to convert is already guaranteed in the Principal Act. So it's not within the minister's discretion. And then the next clause, Honorable Chair, is clause 3, which deals with persons who are aggrieved by the decision to convert, that they may approach the court for appropriate relief. It was stated that that court must be the court that deals with land matters, not ordinary high court. And then the following clause, Honorable Chair, clause 4, there have been comments that have been made with legal arguments that the amendment of Section 25A that seeks to make the Principal Act apply throughout the Republic, it's a measure that is being hastily embarked upon. That is not something that must be rushed. There was also, lastly, Chair, comments to the effect that the committee must seriously consider amending the schedules to the Principal Act, that is Schedule 1, Schedule 2, to provide for other laws that may be seen to be discriminating against women. Honorable Chair, those are the comments that we have uplifted that directly relate to the clauses of the bill. Now, we will deal with those comments and indicate whether the department supports the comments made or not. Where we do not support, we will explain why we hold a different view. Again, on clause, going back to the clauses one by one, the clause under paragraph B, where it talks to maintenance of the way it's Schedule 1, we agree with that proposed amendment. It must have been there in the first instance. I think it was a drafting oversight on our part when we were putting the bill together. So we support that proposal. The second proposal, still under clause 1, paragraph C, that talks to the notices that must be served in addition to the Government Gazette. We also support the two proposals. Firstly, that there must be personal notices or letters that are served on family members who are known to have an interest, or any other person whom the family members may identify as having an interest, so that if they so wish, they can object to the conversion. We also support the proposal that notices may be affixed at local municipal offices, notice boards in local languages for any person who may have an interest to object to the conversion. We support that proposal. The third clause, still under clause 1, paragraph C, that deals with the conduct of inquiries. We also support the proposal that the provisions of the bill must be made clear, that an inquiry must only be instituted where there is an objection to the application the minister would have received. And secondly, that it is important to provide in that section a reference to the other sections of the Principal Act that provide for the powers of the person conducting the inquiry. For instance, that the person can interview persons at a local level where the right is being held to establish the facts around the application. Chair, the next proposal that we support is the one that suggests that the person conducting the inquiry must also have the power to mediate between the parties, so that by the time the minister consultation, if there was a dispute, it could have been resolved between the parties. The next proposal, and still under clause 1, paragraph C, which relate to subsection 1D. That is the part around the role of the minister, that it be made clear in the provision that the minister does not determine whether a person can convert or not. That right is guaranteed in the Act itself. What the minister will be seeking to do is to determine the facts in terms of who is the rightful holder, in terms of the Act, who has the right to convert. The proposal around clause 3 that deals with the court, that it be specified which court will be responsible for providing relief. We also agree that it must be the court that deals with land matters. The challenge in terms of drafting could be that, well, we know at this point that it will be the land court that is currently being developed in terms of legislation that the Department of Justice is currently busy with, but we cannot refer to a bill which is not currently an act. So what we can do is to undertake that as we engage with the Department of Justice on the development of the land court bill, that we indicate in that bill or in that court that it will have a jurisdiction over issues arising from the ULTRA Act. That will also take care of that proposal. And lastly, Chair, the proposal that the Act must not be, the bill must not make the principal act applicable to the entire Republic. We do not support that proposal. Well, firstly, the court has ordered that the Act must apply throughout the Republic. That has been our intention also to do just that. So we do not support the proposal that we must hold that part of the bill. But basically, those are our indications, Chair, in terms of it's almost all the proposals that we have highlighted that we support, except the last one that was with the application of the principal act to the entire Republic. And then we deal with comments that are made on the land tenure in general, outside the specific provisions of the bill, but may also be covered under the last clause that seeks to make the principal act applicable to the entire Republic. Because a lot of comments raised around that relate to communal land tenure. And a lot of them are legal arguments, basically, in terms of, if we were to implement sections 3, 9, and 20 of the Principal Act, together with the part that makes the Act applicable throughout the Republic, a lot of concerns have been raised, and we are trying to address those concerns. And I don't think I have to go through that, Chair, because it's going to take it's some kind of a detailed provisions. Members, I take it that they have gone through those comments, and then where there are points of clarity, so to be happy to provide same, unless the Chair directs that I go through them. They're going to take a while to go through them, Chair, but they are there on the presentation. They are also there on the comprehensive document that we have submitted to the committee, which I'm sure will elicit a lot of debate, because the people who are commenting are raising a lot of legal arguments to which we have tried to respond. In some instances, for instance, those that were raised by the Legal Resources Center, we tried to deal with them paragraph by paragraph, because they are raising interesting legal arguments that seek to understand from the department side how we're going to be dealing with certain issues. But suffice it to say, Chair, that a lot of these comments are around the fact that we have no in place legislation that deals with communal land tenure. We have admitted to that, and also indicated that we, as the department, we are earnestly working on that particular bill. We had hoped that the bill will be introduced in Parliament this year, but it looks like it may not be practically possible to do that, in which case we hope that we should be able to have it introduced next year in Parliament. And the reason why there is a bit of delay, as we've explained in the previous meetings, is because we are consulting widely on that bill. We continue to consult with COPTA, with traditional authorities who have a strong interest in the provisions of the bill. And in relation to this bill, the Ultra Bill and the Principal Act, it is only sections 3, section 19 and section 20, and then section 25A that in particular deal with communal land tenure. The rest of the sections in the Principal Act of the Ultra Act, we have about 25, 26 sections that do not deal with communal land. It's only 3 sections that deal with communal land. And we have not attempted to amend those sections in this bill. It's only to the extent that we are amending section 25A that the issue of communal land becomes central to the discussions. And that's why a lot of comments raised generally center around communal land, Chair. With the Honorable Chair's permission, if I can pause at that point, and then maybe my colleagues may also want to add, and then we take points of clarity that members may wish to raise. Thanks, Chair.
DG and officials of the department, any further input?
Thank you, Chair. Not on my side, Chair. I would support the proposal of Advocate Ramasala that we probably hear any further questions of clarity from the committee members.
Uyayibuyisa ke bawushabana etafuleni kusihlalo.
Kunjalo sir.
Siyabonga bawushabana. Honorable members, there is the presentation from the Department of Agriculture, Land Reform and Rural Development on the public comments that they have received in terms of the upgrading of the Land Tenure Rights Amendment Bill. We will now proceed as the advocate's request to engage in questions of clarity on this presentation, as well as the lengthy presentation they attached on the public comments themselves that came out during the engagements. Therefore, we'll call on the honorable members for your questions of clarity, and then we'll return to the department for responses. Honorable Kape.
Thanks, Honorable Chair. Greetings to the department led by the DG and officials. Chair, I must indicate the advocate and the DG has apologized for late submission of this report. It's putting a bit of constraint on discussion on this matter. I can tell you I only received the elaborate one on other land tenure in general after I logged in. So it is a challenge. And these are the issues, Chair, that needs a thorough engagement so that when we go back to the communities, especially on the general ones, we are able not to lose our stakeholders. We take them along so that they understand what is it that we need to do separate from the bill. Let me go to the bill. Chair, advocate is right. I was just observing. They are agreeing with every proposal except that one, that the bill must not make the principal act applicable to the entire country. Now, you would wonder that us as the portfolio committee, inviting speakers, oral presentation and submissions, and agreeing almost with everything that is pointed to us, or how does it feel? It looks like we didn't do a thorough job, and this was pointed out initially. Now, all this has been brought in by members of the public and the stakeholders to this department and interested parties. Everything the department agrees to. And you wonder what else is still there that is a blind spot for us. Now, I'm happy that they are agreeing, Chair, because us not agreeing with all these clauses that they have indicated would have put us in a very tight situation where we even spoke as the portfolio committee that we would have to look at the desirability of this bill. Now, all those clauses, the department agrees, no, we would have done 1, 2, 3, we're supporting what is being done and everything. Mara, Chair, out of that, I think we'll still have to see what after everything, after we wrap up, where do we stand? I just want to, I don't know, maybe it's there on the general indication, on the general discussion document. The issue of submission made by House of Traditional Leaders across the country, in all provinces. You could see uniformity, you could see that they are agreeing, even the provincial houses are agreeing with the national. Or where does it leave us on issues that everything that has to deal with tribal land must be transferred to them? I have not went through that. I don't know. That is the key issue that came up, and that is one thing that we want to have a feedback to traditional authorities. My last point, Chair, will be, I'm trying to remember, Section 20 was called to be problematic, especially when we started. Everybody was saying Section 20 must just not be there or something. What is the response of the department into that one? The last one is the minister being a referee and a player at the same time. It also came out strongly. And I heard the advocate talking about that the issue of conversion is foregone thing with the Principal Act. Minister just preside over the dispute or where there's something, I don't understand, but it was an issue out of this public participation, public hearings, that it looks like the minister will be a referee and a player at the same time, which doesn't augur well with the public or those that came to present. Thanks, Chair.
Thank you, Honorable Methape. Honorable Mahlo. Mahlo. Honorable Stein.
Thank you, Chairperson. Sorry, I don't have my video on today. Chairperson, yes, I want to agree with what Honorable Klape said. In the first place, we really received it quite late last night. And I even thought maybe we might not have a meeting today. Chairperson, but my concern is that it seems like the department is agreeing with a lot of the proposals that we received during the public hearings. Would it be possible still, with what they have said today, to proceed with the bill in the form it is? If we don't scrap the totality of the bill and start with a new process or a new bill that will cover all the people in South Africa under one unilateral bill that many of the people asked for. My question to the department would be, is do they see that with the proposals that we received and a lot of things that they agreed with today, that we actually can proceed in the bill with the form it is currently? And yeah, I think that's basically my concern question, or my question, Chairperson. I said from the beginning that I'm not sure that we would cover moving towards a uniform South Africa with the way that we are currently dealing with legislation in this department. Thank you, Chairperson.
Thank you, Honorable Stein. We have Honorable Matthias. Honorable Ntate Matthias. Honorable Briet.
Thank you, Chairperson. Thank you to the department for presenting, Chairperson. And I have to say, I share the concern of my two former colleagues or colleagues that spoke before me. I made a note here specifically with regard to the role of the minister, and I said, I think Honorable Klape summed it up nicely, that she is a player and a referee in the game, and they make mention that they need to describe the role of the minister better. And I would also like to see in that regard, should a claimant not agree with what the minister said, would there be an appeals process? Would there be another person that can actually, should you not agree with the minister? Because that is my fear. The minister makes a decision, the claimant does not agree, and at the end of the day, that is finishing clause, that's the end of it, that there is not an appeals process. I would like the department to speak to that. I'm also concerned that we got the submission so very late. And as Honorable Stein also said, and I think that's been a golden thread through the whole ultra process we have been in, is that a lot of claimants also spoke to a lot of some of the other sections within the bill that we were also worried about as committee. And I would like to know, what are the plans forward? Because it kind of feels to me that we are continually necessarily reinventing the wheel. We are now working on these sections because there was a court judgment in that regard, and that we're kind of just addressing that, and we'll worry about all of the other unconstitutional matters later. That is maybe just my submission, Chair, and my question regarding the role of the minister. And also, I think on page 5, they also mentioned that they would more clearly a proposal that more reference needs to be made of the powers of the land rights inquirer, and I would like to see those things stipulated out more clearly and be more defined as to what do they have in mind for us as the committee. Thanks, Chair.
Thank you, Honorable Briet. And we move on to the Honorable Kapa. Tim.
Thank you, Honorable Chair. I don't have questions. I am covered, Chair, except to mention also that I'm also happy that the department is highlighting the fact, this issue of the rural land, the communal land. But again, I wonder how it would have been done, that there's always indication that quite a lot of concerns were subject matter of other legislations, which would always be raised by people because they are not aware that, no, this one is addressed in another legislation, was being addressed in another legislation. So that's the only issue. Thank you, Chair.
Thank you, Bao Kapa. The Honorable Mema Hlati.
Thank you very much, Chair. Let me also join my colleagues in following on what Honorable Klape has indicated. I support fully what Honorable Klape is saying in as far as the comments by the department is concerned. But I would also agree with the fact that I think we have raised this matter before, Chair, about bills that are related to our portfolio, that we ought to look at them, we ought to review them and see what works, what doesn't work in the current conjuncture. However, in this particular process, I would want to maybe request that honorable members of this portfolio committee, we proceed with the process rather than reopening the entire bill at the moment, precisely because there's taxpayers' money that has gone through this process. Let's go through with this one so that we are able to complete the matter as per court decision. However, we ought to ensure that we look at all these other bills, including this one, holistically, and say what is it that is working and what does not work. Moving from that ship, Chair, I just want to find out, because the department in its response is saying to us, we are accepting this, we are not accepting this, but it does not indicate for what good reason are they accepting and not accepting. You know, and I'm raising this one specifically on those that they are saying they are not accepting as per recommend. I just want to understand the logic behind them saying you are not agreeing, because where they're agreeing, I think we will be fine as a committee, as well as indicating the processes of logic, Chair, maybe based on the experience that we had in Section 25, in as far as an appeal is concerned, that legislation does not necessarily become the alpha and omega. In a situation whereby there is a dispute, we can still go to the Constitutional Court, just like in the Rahube case, unless we are saying it must be explicit in this particular legislation. But normally that would be the route to take in as far if there is a dispute in as far as legislation is concerned. And I would also I don't see why it should be there to indicate, to be explicit, when there is of course an alternative measure to ensure that this matter is taken through. But lastly, Chair, No, I think those will be my comments, Slav. Thank you so much.
Mema Hlatsi, thank you for your questions of clarity. Can I please plead that we mute our microphones? Mamu Pumzile Ngwenya Mabela, please mute your microphone, and Mamu Togozile X, please mute your microphone. I'd now like to invite the Honorable Lumamu Babama.
Thank you very much, Chair. I must say I've been covered by my colleagues. Diabulela.
Nkosi Mamu Babama. Honorable Masipa.
Thank you, Chair. Sorry, my camera is not going to go on now, if you don't mind, Chair. Chair, I think I'm covered, but I just want to raise one or two things here that were raised in the hearing. The issue of the lands that are owned by churches and commonage lands, I think they were quite raised by the doctor from UCT. And obviously the lease land, state land, as to how it's they're gonna be addressed. The last one obviously is section 19 and 20, which many felt that it is flawed. If the department can also address it on that one. Thanks very much, Chair.
Thank you, Ntate Masipa. The Honorable Ndabezitha Kosenkulu. Bawucebekulu.
Thank you, Mthembu. Thank you, Chairperson. I don't think I have much to say on what has been just in the briefing by the department. Unfortunately, I've been starting to connect, Chairperson, but all I could say is the understanding that I have, and I had when the bill was presented, was that it was mostly focusing on dealing with the issues of the PTOs, of people who are living in towns and townships, or where they have disadvantage, especially women with disadvantage, having the rights, as well as furthering down to the dependents, who, when the owners of the property or the house passed on, and the family members, the kids, would maybe start fighting amongst each other for the property. But the understanding I have, Chairperson, when it comes to issues that were raised by some of the what I call the presenters who were submitting their views, was that some would
Ndabezitha. Kosenkulu. We seem to have lost the Honorable Sebekulu. We'll see if he is able to rejoin and attend to his questions also. Any other honorable member that I've missed would wish to ask a question? Perhaps honorable members just to also deliberate on the issues of the constitutionality of the bill. I'd also like to understand, Dabezit, have you been able to come back, Kosenku?
Fortunately, talking to myself after having disconnected, unfortunately. But Chairperson, I take what other presenters did mention with regards to bearing in mind that we have a communal land where people are sharing as an extended family on some of the issues. But the understanding I have is that this bill currently deals with the properties in towns and townships, and it needs not to be confused with the setup in the communal land or rural people. Thank you, Chair.
Thank you, Dabezit. Honorable members, as I was saying, that mine is to really to ascertain if there are any constitutional challenges that might arise through this bill as put by yourselves. And I think a number of you have asked on this, has asked clarity on these issues. And I'd like to gain a real thorough understanding or explanation of how the department is seeking to deal with the unintended consequences of making the bill applicable to the rest of the country. But also the stakeholders said that making 19, clause 19 and 20 applicable to the entire Republic of South Africa without recordal or existing rights, this might erode rights allocated in terms of customary law. What is the department's response to this? But also, I think, honorable members, that there are many issues that the department has raised in the long word document, which there must be time given to deal with it. Some of these go to the heart of policy positions in respect of land tenure, which this committee is yet to be briefed on. And an example of that will be land titling in communal areas versus customary tenure rights, and etc. This is a matter we should discuss in the future. I would now hand over, honorable members, to the DG, Ubao Shabane, and the officials of the department as to respond to the questions that have been put on the presentation that was made by the advocate. DG?
Thank you, Chairperson. There is a technical team that I'm going to invite to respond to the comments, and I will add where there are issues that may not be responded to. I've got Advocate Ramatsala.
My apologies, DG. It seems we have Honorable Montwedi that has joined us. Ntate Montwedi, you are most welcome. Would you have any questions of clarity on the presentation that has been put to us by the department?
Chair, thank you very much. Good morning, everybody. Am I audible, Chair?
Yes, you are audible, Ntate. Please proceed.
Yeah. Thank you very much. I think the question that I wanted to pose to Chair is with regard to the submission that I had from the stakeholders with regard to section 19, but they were referring to section 3, 19, and 20. If I can just add 3 and 20 to what you have already said, so that the department can actually be able to respond also on 3 and 20, Chair. That's what I actually wanted to put, Chair. Thank you very much.
Thank you, Dr. Montreди. DG, our apologies for interruption, but please proceed.
Thank you, Chair. I've got Advocate Ramasala, Advocate Ngwengwe, and I would ask them to respond to the questions that have been raised.
Thank you, DG and Honorable Chair. I will start with the points of clarity sought, and my colleagues will fill me in. So pose at the end. The concerns raised by the Honorable Chapter, firstly on the transfer of communal land to traditional authorities as raised by traditional authorities in their comments, and then linking that also to Section 20 of the Principal Act. And I will come then to the role of the minister. On the first two matters, as I've indicated, the provisions in the Principal Act that relate to communal land is basically 3 sections. It's sections 3, section 19, and then section 20. And also to the extent that section 25A, we are seeking to make it applicable to former TBVC states. It also relates to communal land. Now, they are not the issues that are covered in the bill, because the bill does not seek to amend sections 3, 19, and 20. However, because a lot of comments have been made around that calls for the department's position on what we believe should be the case in relation to transfer of communal land. As the Honorable Chairs rightfully stated, those are matters that we are seized with as we develop the communal land tenure bill, because it is in that bill that we deal with that aspect. The reason why it has arisen during the engagements in the bill is because the Principal Act, Section 19 and Section 20. Section 20 provides that the minister may transfer communal land that is held by the state and trust for the state to the community. And then Section 19 provides that a community becomes a legal entity, which means it can transact in its own name, which means the community can be able to receive land that the minister transfers to it by itself as a community, as a legal entity. And then Section 3 deals with the conversion of PTOs, mostly, or customary land rights into ownership, in as much as it was Section 2 deals with conversions of deeds of grant or township family houses to ownership. But in our observations, sections 3, 19, and 20 that deal with communal land have not been implemented, in my understanding. We have not had instances. If we have had there may not be many instances where the minister was requested by a community to transfer communal land, and that was indeed done. But that's basically what the position is. Those are the issues that we're dealing with in the communal land tenure bill, which means that when we deal with those issues in that bill in detail or comprehensively, the communal land tenure bill will have to repeal of ultra, because it will be the right legislation to deal with those issues, not the Ultra Act, because plus minus 26 sections deal with urban tenure. It's only those 3 sections. On the of the role of the minister being a referee and applier as raised by stakeholders, I think that impression of the minister being a referee and applier arises from the comments they've made, that if you look at the manner in which the is couched in the bill, it suggests that in addition to receiving the applications for conversions and considering them, the minister determines whether there must be a conversion or not. And that's the part that we're trying to clarify, to say that the right to convert is already guaranteed in the Act. What the minister does is to consider applications with a view to determine who is the rightful holder of the right that can be converted. Moving on to the points raised by the Honorable Steyn. Firstly, if we proceed with the bill in its current form, will that assist? Basically, can we move with the
Advocate, you are not audible.
Those provisions may read a bit ambiguous or unclear. There will still be questions as to whether, in receiving the application, what is the role of the minister? People will still be asking questions. Whereas if we can clarify it in the wording of the provisions of the bill themselves, those uncertainties will be cleared. It's just one example. For instance, the first comment made on reference to Schedule 1, if we leave it as it is, which suggests that reference to Schedule 1 is deleted by the bill in the Principal Act, it leaves some uncertainty in terms of, are we talking about the land rights that are contained in Schedule 1, or is any other land rights, even those that are outside Schedule 1, in respect of which the minister must receive applications? There will be a bit of uncertainty, but it does not mean that the provisions are totally unworkable. And the second point that has been raised is what can we proceed with the bill in the absence of comprehensive legislation that deals with communal land tenure? We agree that ideally we would have preferred that communal land tenure legislation be dealt with first. But the challenge is we have a constitutional court order that says we must amend the Principal Act as we're amending it. Hence, we have had to amend the Principal Act whilst at the same time still trying to finalize communal land tenure legislation. And as I've indicated, it's also important to note that out of about 26 sections of the Ultra Act, only 3 deal with communal land tenure. The rest deal with urban land tenure, the opening of township registers, deeds of grant, and related matters. The points of doubt raised by Honorable Briet, firstly, again, on the role of the minister, I think I've tried to clarify that. And then the question specifically was whether there is an appeal against the decisions of the minister. Generally, the decisions of the minister are administrative decisions. And then if persons are aggrieved by those decisions, they can take those matters on review in the High Court. That's the normal process that we do not have to provide for in legislation. In addition to that, if one can have regard to clause 3 of the bill that seeks to amend that 16 set, section 14A, where persons who are aggrieved by the conversions that took place have the right to approach the courts, which is the point that I made, that comments were saying that we must specify which court is going to be dealing with that matter. We have said that it's going to be the land court that is going to be dealing with those matters. That is still being developed in terms of also a bill that is still being developed by the Department of Justice. Honorable Briet also referred to the reference to the other sections of the Principal Act that deal with the powers of the person conducting an inquiry. That can be done with ease. It's simply to uplift those sections and refer to them in that clause. It shouldn't be much of a challenge. Just redrafting that section to make specific reference to the sections that already exist in the Principal Act. It's not, we're not introducing anything new in the bill. The Chair, I must apologize. I missed the point raised by Honorable Kapa. Let me proceed with the others. Maybe I can come back to it when it's raised. I must have still been taking down notes when the point was, so I missed it. The points raised by Honorable Matlasi, why do we must give reasons for accepting certain comments or agreeing with them, and then also explaining why we do not agree with certain comments made. With those that we agree with, the only reason we agree is because we believe that there will clear uncertainties that may still exist from the wording of the bill as it is. It will clarify the provisions and then make sure that when the bill is read, the provisions are clear. The ones that we do not agree with is basically the one that deals with Section 25A. We do not agree with the proposal, firstly because we have been ordered to, well, that's a section that has been declared unconstitutional because it does not apply throughout the, so we have no choice as a department but simply to comply with the court order, which we agree with in any event, that this legislation should have applied throughout the Republic. Because if it does not, we cannot have a situation where certain laws apply in certain areas and do not apply in others. That's a recipe for disaster. So we agree that the Act must apply throughout the Republic.
Apologies, Advocate Ramasala. Can you please switch on your video? I'm informed by communications and IT that we are live on social media. So please switch on your video so that our guests elsewhere can be able to see us. Thank you. You may proceed.
Thank you, Honorable Chair. I was dealing with the points of concern raised by Honorable Matlasi, sorry. The other point raised is in relation to the disputes that might arise as a result of the minister's decisions. I have indicated that those administrative decisions, they can be challenged in any court by means of review applications, and then also that the section 14A that we are inserting through the bill make reference to persons approaching the court to have disputes resolved. The points of concern raised by Honorable Masipa deals with land held by or owned by churches, communities, and state land that is being leased. Those are issues that we're not dealing with in the bill. There are also not necessarily matters that are dealt with in the Principal Act. In terms of how the department deals with leases of state land, I'm sure my colleagues who are responsible for that division can explain how the department is dealing with those issues in the context that have been raised. Also, Honorable Masipa referred to sections 19 and section 20, that comments were made that the sections are flawed. Basically, as I've indicated, section 19 provides that a community is a legal entity which can transact on its own, which means it can receive land in its name. Section 20 provides that a community may request the minister to transfer communal land to that community. As I've indicated, the bill is not tampering with those two sections. And I'm sure in terms of implementation, whether we as a department have been implementing those particular sections, I'm sure the DG can fill us up on that part. But as I've indicated, the bill does not deal with those issues. Sections 19 and 20, the sections are raised because section 25A seeks to make the act applicable to the entire public, which includes these particular sections and section 3. The points raised by Honorable Kulu that the bill basically deals with township houses. It is entirely correct. Section 2 that was declared unconstitutional, which forms the basis of the bill, deals with township houses in the form of deeds of grant. That, as I've indicated, it's only sections 3, 19, and 20 that deal with communal land, which the bill is not tampering with in any form, except to the extent that section 25A is made to apply throughout the Republic. The points of clarity raised by the Honorable Chair with regard to the constitutionality of the bill, we are confident that the provisions of the bill are constitutionally compliant. We have no doubt about that. Firstly, because they seek to correct what the court has indicated needs to be corrected, and they've been done in a manner that, in our view, is constitutionally compliant. There may be issues of uncertainties in terms of the language, as I've indicated, which are the points that we agree with the comments made, that can be tweaked to make the sections read more clearly. The second point raised by the Honorable Chair is the unintended consequences of making the Act applicable throughout the Republic. as the point raised by many stakeholders. I know that the LRC raised it. I think the institute from the University of Cape Town also raised it. The issue that is being raised here is that if the Act is made to apply throughout the Republic, and then sections 3, 19, and 20 are implemented, the state runs the risk of transferring communal land in terms of section 20 without clear protection mechanisms for rights that community members already have. Those include customary land rights, family rights to property, household rights to properties. How do we provide for the protection while transferring the land to the community? The fear being that, which is the assumption is that when the state transfers this communal land, it's going to transfer it in the name of a traditional council or traditional institution. And they're saying that by doing that, we'll be eroding the rights of individual holders. They're also saying that by transferring communal land to a community, we are making a community and the traditional council a superstructure that is going to be holding the property on top of individual members and thereby eroding their rights. And we are saying in response to that, that if we, for instance, the one that was declared unconstitutional, the manner in which transfer of communal land was done was such that the entire communal land is transferred to a community in that community's name. But at the same time, the subdivided portions for residential and business purposes were transferred in the name of community members who are occupying those properties in ownership. That in itself ensured the protection of those individual family household rights against the community itself. Because the argument was that if you transfer to a community and leave it to a community to determine the kind of rights that are going to apply to members, the community may decide that it is going to only extend the right of use, not ownership rights in respect of residential stands. Now, the Constitution guarantees, if you look at section 25(6), it talks about the rights of persons and communities, which means persons are also entitled to land tenure that is legally secure, not only communities. It is in that context that they raised the concern that in transferring communal land to communities, it must be made sure that individuals' rights, family rights are also protected. And as I've indicated, the manner in which the transfers took place in DALRRD is the manner that we are envisaging it. And I think also the LRC is making the point that DALRRD was declared unconstitutional because it failed to protect those rights. We do not agree with that view. The reason why DALRRD was declared unconstitutional is because DALRRD, in addition to transferring communal land to communities, indicated that traditional authorities will retain the right to administer communal land, which is the part that the court objected to at the High Court level and ruled that that was unconstitutional. The points of clarity raised by Honorable Mundweji, I think the concern was to put sections 3, 19, and 20 into perspective. I think I tried to do that, to explain the link between sections 3, 19, 20 of the Principal Act that the sections are there. The bill is not tampering with those 3 sections, but to the extent that we are amending Section 25A to make the Act apply throughout the Republic, by indication, we are dealing with those sections. Because whereas currently these sections do not apply in the former TBVC territories, with this amendment bill, the sections are going to the Act is going to have to apply through, including the sections, to those territories. It is in that context that the sections have been referred to. Chair, as I've indicated, I think it's also important to emphasize the fact that if you look at the DALRRD Act, it's not an act that creates land rights. What the DALRRD Act does, it simply refers to those acts that create land rights in its schedules, Schedule 1 and Schedule 2. Now, to protect and deal with those rights, DALRRD will not necessarily be the best lesson because it does not deal with those. The DALRRD only provides for a process of conversion of the rights provided for already in other pieces of legislation, which are listed in the schedules. Now, what we're saying is that the challenges we have with those other laws are the challenges that we are dealing with when we are developing communal land tenure in the main, because that's where a lot of problems are. With regard to urban land tenure, DALRRD deals with those issues. And then urban land tenure, the challenges are instances where individuals have no title deeds to properties they already occupy. This could be RDP houses, it could be townships that have since developed around townships that are still informal, where individuals own properties, but there are no title deeds. And that involves other departments, settlements in terms of issuing title deeds as and when land rights are created and respect with those individuals. That is with urban land tenure. And it's not the solutions with regard to urban land tenure is not as complicated as communal land tenure, because with communal land tenure, you deal with indivisible entire communal land and then the divisible residential portions where the rights are different. As a community member, I have the right to my individual stand where I've built my property or businesses. At the same time, I have access to the indivisible portion of the community if I have got livestock, to have my livestock graze on that piece of land. For cropping purposes, if I need a piece of land to plow, and then also access to forestry and rivers. That is the part that is owned by the entire community, where every community member has got access to that piece of land. Now, piece of land. Now, I think there was a comment made by a traditional leader, I think from Barolong Molefe, I think, if I'm not mistaken, where he made the point that with communal land, if the state transfers communal land in individual title, for instance, to individuals or families, he gave the example of if there are 4 siblings, for instance, that if the property is transferred in the name of one sibling, then it deprives the other siblings of their right to ownership. I think that is a matter that must be dealt with in terms of applicable laws of succession, whether it be customary laws of succession or any other laws of succession, as long as those laws are not applied in such a manner that they infringe upon the rights of women, children, and unmarried persons, because customary law must also be interpreted in the context of our current constitutional regime. Honorable Chair, I think that I've tried to cover as much as I've been able to take down as points of clarity raised by members. And I'm sure my colleagues may want to add where I may have missed some of the questions raised. Thank you very much, Chair.
Chair, can I ask Advocate Mgwengwe?
Thank you, DG. Advocate Mgwengwe, please proceed.
Thank you, Chair. Chair, I will respond just to a few that my colleague may have missed. I won't go through everything that he has gone through because he has sufficiently responded to the question. There was a question by Honorable Chapter. It was actually a comment that submissions made by traditional leaders regarding the transfer of land to themselves, she was saying it was a single voice, irrespective of where they were coming from. So, Chair, I've decided to comment on this because of the comment that was made by Nkosi Nokonyane at the time when he was presenting. He specifically said there was an agreement that they reached with our department that communal land in 2018, that communal land shall be transferred to traditional leaders. That's how he said it. So, Chair, I think then I have to clarify that. What happened to person is that traditional leaders called an indaba, and they had invited government in that indaba, where our minister also participated. And during indaba, traditional leaders took resolutions. Amongst the resolutions taken was that communal land had to be transferred to traditional councils within a specific period of time. Now, I think the mistake that is happening is that there's an assumption being made that because cabinet ministers were in attendance, by virtue of resolutions being taken in their presence, it then means that there was an agreement between government and traditional leaders to the effect that communal land will be transferred to traditional leaders. Chair, there is no government position with respect to transfer of land to traditional leaders. That decision does not exist. Yes, cabinet ministers may have attended the meeting, the indaba, where the issue was discussed, where resolutions were taken, but on the side of coming back to government and government engaging on the issue and taking a resolution, that has not yet happened. Yes, indeed, there are conversations. It's a conversation that is open, that traditional leaders have continuously raised with government. It's a conversation that is happening, Chair. There's no resolution, there's no agreement. I'm stating this because of the suspicions that came quite clearly during the public hearings. particularly with respect to the inclusion of Section 25A, therefore the application of Sections 3, 19, and 20, that it seems to me that there's a concern that we are doing so that we would then give effect to this promise that we have already made that communal land is going to be transferred to traditional leaders. And that's not the case. That's not the case, Chair. Let me just add on that issue, Chair, or on the issue of Section 3, 19, and 20. I think, Chair, what needs to be appreciated is that the non-application of Sections 3, 19, and 20 throughout the Republic is in itself unconstitutional. Because what it does is that, because Sections 3, 19, and 20 apply in some parts of the country, now the non-application of the same sections in the areas that were under TPVCs, what it does is that it introduces a differentiation between those areas and the areas where it applies, and that differentiation has got no rational basis. And for that reason, that in itself becomes unconstitutional. So all that we are doing is that we are correcting an unconstitutionality that has already been highlighted through the Sengu judgment. Yes, we may accept that there could be implementation challenges as a consequence of an immediate application of the 3. It's implementation challenges that we have to prepare for, because we will not be able to sustain why they would not apply throughout the Republic. Then the next issue, Chair, was raised by Honorable Chapter. That's the issue that my colleague was saying he did not capture it because he may have been writing notes. That issue, Honorable Chapter is basically saying there were various concerns raised during the public hearings. And it is unfortunate that those concerns that were raised, they seem to relate to a subject matter of another legislation, meaning general concerns revolved around communal land, and we are saying there's going to be a communal tenure legislation that will be brought in to deal with those issues. He was just raising it as a concern that there are all these issues that are a concern to a lot of people, and unfortunately they're not being addressed at the present moment, and we're saying they'll be addressed through some other legislation that will be coming through. So that I take that as a comment, Chair, and I think Advocate Lamasala dealt with that, though even not in specific terms, by simply saying that there is an effort to deal with the subject matter of communal land through legislation. Then there was an issue that was raised by Honorable Masipa relating to commonages and church land, as well as leased land or state land. Chair, the limitation there is that there was no context that Honorable Masipa laid for those points. What though we can say, Chair, is that with respect to commonages, you generally are going to find 2 types of commonages. You're going to find municipal commonages. You're going to find commonages in the traditional sense, in the sense that you'll have a common area that is used, and that which is maybe used for grazing is then referred to as a commonage, which therefore could more likely be related to what we refer to as communal land or state land. So with respect to commonages and church land, Chair, I think the issue about church land is that you find communities on land that was given to a church. And therefore, those people residing on that land have got some sort of rights which are not necessarily secured. Chair, one, as my colleagues has mentioned, one is that we are at present moment writing a communal tenure policy. Two is that, which will deal with communal, Chair, we're writing a tenure policy, not communal tenure, a tenure policy, which will deal with tenure reform broadly, not just communal. So from there, then we move into legislation. Yes, there is a bill already in the public domain, but we're hoping that the process of producing a tenure reform policy will also enrich the legislative process relating to the communal tenure bill. So as we do so, part of what we're coming across are land administration matters that will relate to rights of people on land other than land controlled by the state. And we're hoping, Chair, that as these processes mature, we're gonna be able to deal with the rights of people that are sitting on church land. We're gonna be able to deal with communities in whatever form they are. Then when it comes to the issue of leased land, I'm not sure, Chair, of the context about leased land, but it said leased land and state land. Now, the concept of state land, it generally gets confusing in the sense that what we generally refer to as state land in the context of former homelands is actually communal land. It is referred to as state land because it is registered in the name of the state, but it is land being used by communities, and we recognize those communities as de facto owners of that land. So therefore, when we deal with the communal land tenure bill, we're going to be dealing with that land that is referred to as state land, unless the honorable member was referring to another type of state land. Because in terms of state land, you're going to find land that we acquired as government since 1994 that we're using for land reform purposes. I doubt that he was referring to that. I would be inclined that he was referring to state land that is relevant to the subject matter, which will definitely be communal land. And we're saying we're going to be dealing with that in the context of the communal land tenure bill that we're going to be bringing in. Those are the two issues, Chair, that I think were left out in Advocate Ramasala's response. Thank you.
Thank you, Gwengwe. DG?
Chair, I believe the team has exhaustively dealt with the issues unless there are follow-up questions. Thank you very much.
Thank you, DG and officials of the department on the responses on the questions of clarity posed by the honorable members. Are there any follow-up questions, honorable members, on the responses? Honorable Chapter.
Chair, I'm good.
Thank you,
I have
Honorable
no follow-up question. Thanks.
Thank you, Metape. Honorable Mahlo.
Honorable Chair, thank you very much, and also apology for connecting late. I missed my calendar, but I don't have any questions. I think I'm covered for now. Thank you.
Thank you, Honorable Stein.
Chair? Chair?
Yeah.
Sorry, it's Honorable Masipa here. Honorable Stein had to be excused.
All right.
She's not.
Thank you, Honorable Masipa. You may proceed.
Okay, Chair. Yeah, I think the department just clarified my question and obviously asked the context of the question. I think it wasn't really directly my question, but it was something that was put by Dr. Zabai from the University of Cape Town with regards to these issues. So they were raised during the submission with regards to this, issue of commonage land, church land, leased land, and obviously the issue was to say that the bill is commendable, but is far short of addressing the issues. But I think I just want to thank the explanation that is provided with regards to how those matters will be dealt with going forward. Thanks very much.
Thank you, Honorable Masipa. Honorable Babama. Mamum Babama. Honorable Priet.
Thanks, Chair. I am covered.
Thank you. Honorable Kapa.
Thanks, Chair. I'm happy that they're about their response. I only wish there was a way of maybe again communicating to those people with these concerns, make them know that the department is really having this capacity and ability to deal with these legislations in other areas of legislation, because they seem to not to understand from the order that there are different legislations, and therefore sometimes give impression that their concerns are not being attended to. Otherwise, advocates have understood and explained this situation. Maybe the department can have some part of a education process to make people understand that not all issues of land can be addressed in one piece of legislation. Thank you, Chair.
Thank you, Mthembu Mkhulu. Honorable Mahlatsi.
Thank you very much, Chair. I also share the same sentiments as Babu Kapa, especially on issues of education, to ensure that our people are made aware, because number of issues that were raised could have been or are covered in numerous programs of the department over and above legislation. So I would also request them, as they do these programs, we do educate our people, especially in the rural areas of our country. It is quite important. But over and above that, thank you very much, Chair, and the team from the department.
Thank you, Ma'am Mahlatsi. Honorable Muntwedi. Ntate Muntwedi. We seem to have lost the Honorable Muntwedi. Ndabezitha, Kosenkulu. Honorable Tebekulu.
Thank you, Chair. I don't have any comment or follow-up question at the moment. Thank you.
Ndaba, Abulela, Nkosi Tebekulu. Any other honorable member who wishes to have a follow-up question whom I've missed? Thank you, honorable members. Perhaps if I may probe further on the response from the advocate Ngwengwe, particularly from the input made by Contralesa, and specifically His Royal Highness Unkosi Mwelo Nonkonya. Is the department therefore saying that communal land will not be given back or transferred back to traditional authorities or traditional councils and their communities? Is that the response of the department? Thank you. DG and officials of the department. Any?
Honorable Chair, it's Ramasela, can I maybe the first bite on it, and my colleagues will fill me.
Okay.
In the Honorable Chair, when we look at that matter purely from a legal point of view, what becomes clear is that a traditional council is an organ of state. If the minister was to transfer communal land from the national department to a traditional council, that will mean transferring to another organ of state. It will not be a transfer at all, because the land will still be held by an entity of state that is performing a public function in terms of legislation. So that will be a challenge, that it will not be a transfer at all. It will continue to be held by an organ of state. Thanks, Chair. That's the legal matter that we have to contend with. How do we deal with that? And maybe we had made this point in one of the endeavors to say maybe traditionalists can help us in that regard. How do we transfer land in a manner that is not unconstitutional? And that's where we are still trying to deal with the issue. Because where we stand, it will not be a transfer at all. It will be shifting from one state entity to another organ of state. Thanks, Chair.
Chairperson, may I hear Advocate Ngwangwe? Yes.
Thank you.
Chair, you're putting us in a corner with this question. Chair, there are various possibilities. Let's address this issue of traditional council. We have listened to traditional leaders. We've been in meetings where they were engaging with our leaders in government. And Chair, I agree with Advocate Ramasala, but part of the issue that we've been grappling with is whether the transfer to a traditional council is equivalent to a transfer to a traditional community. And our suspicion, Chair, is that it is not. The traditional council is not necessarily the traditional community that is in occupation. It's a structure, it's a management structure. That is what the traditional council is. So a community is capable of owning land in its own name, separate from the traditional council. So therefore, the questions that we've been trying to get answers to, we even sought a legal opinion on it, which we're still trying to follow up, is whether the transfer of land, of communal land to a traditional council does not amount to dispossession of the community. We had also, in our engagement with the National House of Traditional Leaders, put this question, and we had invited them to just look at, to just research it on their own, whether it is equivalent to the same thing. What we do acknowledge, Chair, is it is possible that communal land can be transferred to communities. But what we also acknowledge is that within communities, there are certain desires by community members to own land, particularly residential land in their names. And we're saying that is possible. As a result, Chair, we have listened to traditional leaders. Part of what they've said is they've made indication of preferences of tenure rights. They said they prefer PTO. They don't want freehold. That's part of the challenge, Chair, is that the question that we had put this in the workshop of the House for them to just ponder on whether it is possible in the current constitutional dispensation to create a tenure right and then limit it geographically and say it applies in that area, it does not apply in that area. Chair, we don't think that is possible, that you can do so. Because what you'll be doing is you'll be differentiating between people on the basis of where they are located. And we don't think that will be rational and it's going to be supported by our constitutional dispensation. But we had invited the House to just do a little bit of research on it on their own to see whether that is a possibility, so that we don't have this conversation in abstract and we get to a point of having to produce a law and we discover that actually we don't want to put it as if it's just our view that it cannot be done. We're saying, let's all research and come back with what we find and see whether it cannot be done. So the straight answer to you, Chair, is communal land can and is capable of being transferred to traditional communities, not necessarily traditional councils. And it is capable of being transferred within traditional communities to individual households who are residents of the areas concerned, where you could exclude common spaces in the same way it happens in town. We live in residential estates. We own my house, but we've got common spaces that we share as a homeowners association. It can happen in communal areas. Thank you, Chair.
Chair, I hope that responds to your question. I think just from a policy point of view, the colleagues are saying there is a commitment with regard to the state divesting itself of ownership of communal land and transferring it to its rightful owners. So the mechanics that Vela advocate Ngwengwe is talking about is what needs to be sorted out. And the discussion that is happening at the present moment is to say, how best does one do that? Thank you, Chair.
Thank you, DG, as well as let us appreciate the input and the engagement that we've had with the officials of the department, particularly the presentation from Advocate Ramasala and the input further made by Advocate Ngwengwe. It has enlightened us and clarified some of the concerns that we came across during the public hearings. This, honorable members, brings us to the end of our meeting, as we wanted to engage with these public comments that were made. And I think it will give us an opportunity to have this discussion that has been raised by the advocates, which should go further to be tested against Section 3, 19, and 20, if it's being applicable to South Africa in its entirety and what that means. We will revisit this in another time when we look further into these matters. But honorable members, I think with that said, we will then await a presentation which will be made by the content advisors as well as the researchers and legal services on the way forward regarding these inputs we've had on the public hearings and the comments that have been made by the department regarding the inputs they received. Our next meeting, which is scheduled for this term, should be next week, which will probably be around, I see Umamu Kakaza is speaking about the 4th of August. No, we are on the 1st of September. So I would take it that our last meeting is Friday the 4th, Mamu Kakaza, isn't it?
Yes, Chair. Friday the 4th of September. Sorry, Chair.
Yes. So we will be having that last meeting to engage on with our content advisors and the researchers, and also receive a legal opinion on the upgrading of the Land Tenure Rights Amendment Bill and what the way forward is. That, honorable members, will conclude our work for this term, and we will then proceed to constituency week next week. With that said, I'd like to thank the DG as well as the officials of the department for the presentation and the engagement. And we plead once again, DG, that the presentations should be submitted to the Secretariat on time to enable the honorable members to have ample time to engage with the documents so that we could be fully prepared for the meetings. It enables us to have fruitful engagements when we meet with the department if we've been able to receive the documents in time. So I would like to appeal that your office ensures that every Friday we have, by end of business day, have ensured all documents have been sent to the Secretariat so that they could be able to circulate them to the honorable members, and we can utilize the weekend to engage with the documents. I hope that we can be able to rectify that and have a proper flowing system of for information. Honorable members, thank you for the session, and the meeting stands adjourned.
Thank you.